Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.
Welcome to the podcast. Here's Beth Mulcahy.
Good morning, everybody, and welcome to First Fridays with the Mulcahy Law Firm. Sorry we're running a little late this morning. We had some technical difficulties. So glad that you're here with us. Looks like we have a great turnout this morning. Looks like over, I don't know. We'll have to see how many people are here. But last time I checked, it was 53, 56, 57. So it's going up. So thanks, everybody, for being here today for our September First Fridays. Back to school time for everybody, and also big time of the year with the 2024 new legislation going into effect next Saturday. So thanks so much for being here today. Just some quick introductory remarks. My name is Beth Mulcahy. For those of you who may not have met me before or listened in on First Fridays previously, and I'm the founder and the senior partner for the Mulcahy Law Firm in Phoenix, Arizona. Welcome to our September First Friday live virtual event. So happy that you could be here this morning. Just some background information on myself for some of you who I may not have met before in person or via these classes. I've worked with representing associations, planned communities, and condominiums in the state of Arizona for almost 28 years. November 1st will be my 28th year anniversary. My firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. And I also currently serve on my HOA board and have for many years. First Fridays is a great time for all of you to get your answers regarding Arizona HOA and condo law answered at no charge. Just a quick friendly reminder, due to the large volume of questions that we receive, we have over 55 already this morning as of 8:45 a.m. This free opportunity is limited to one question per association. So if you plan on submitting a question live during the session today, please indicate the name of your HOA or your condominium and your current role when you submit your question. Okay, first thing we're going to do is talk a little bit about a couple of different laws that you need to be aware of this year. As you know, our legislature ended the legislative session about 80 some odd days ago. And there are a number of bills that you need to be aware of because all of these new laws are going into effect on September 14th, which is a week from tomorrow. And so what I would like to do is start the class today and just talk about some things that you need to have on your radar with regard to the new legislation. And then also, talk about some other laws that you should just be aware of for your association. So I've been doing this for almost 28 years. I can just say, as a starting point, this has been a heavy year for legislation for associations. Some years are light, some years are heavy. This is a heavy year. Unfortunately, we have a lot that we have to cover regarding the new legislation. And we also have, it's just been a busy year for legislation. There's state laws, there's federal laws that you need to be aware of. So let's talk a little bit about a quick and easy guide to the Arizona 2024 legislation. I had spent the last 3 months thinking about and coming up with the easiest possible guide to help all of you digest the new laws that are going into effect a week from tomorrow. And so basically what I did is I asked my office to share it with you. I literally just finished it late last night and put the finishing touches on it this morning. And it's basically just a quick 2-page summary of everything you need to know about the new legislation. So let's start out with just the easy stuff. First, the new laws are all going into effect on Saturday, September 14th, a week from tomorrow. And I know that my office, just hot off the press, you're getting a first peek at what we are sharing regarding the new legislation. We haven't even disclosed this yet on our website or anywhere else. So you're getting the first look at it. And basically what I'd like to do is just go through quickly what the new laws are in the easiest and quickest possible way. So I'm following off the new quick and easy guide that our office has shared on the chat in Zoom. And we're also going to be putting it on our website soon as well. Okay, so first thing, there's a new requirement regarding meeting agendas. It's pretty simple. When you send out your notice of meeting for your associations, you notice of board meetings, you also need to send out the agenda. So this law applies to planned communities and to condominiums. So meeting agendas must be provided with the meeting notice to owners 48 hours in advance of a board meeting. And this can be done by hand delivery, mail, website posting, email, or any other electronic means of posting at a community center or any other similar location. So new requirement, meeting agenda must go out with the meeting notice for board meetings. Okay, next requirement, if you have any fair housing violation language in your association's documents, this applies to planned communities and condominiums. A board can now remove any of those provisions in the CC&Rs that violate fair housing laws without a vote of the membership. This new law also provides a procedure for members of the association to remove provisions in the CC&Rs that violate fair housing laws. I don't think we're going to see this being used very often, but some examples of fair housing violations, in my opinion, in documents would be obviously that anything that on its face discriminates, against any of the protected classes under the Fair Housing Act are going to be something that could be removed pursuant to this section. Also, another thing that we see from time to time is where, let's say that there's a provision in your CC&Rs that states that the board can approve or deny anybody from purchasing a home in the association. That's on its face something that should not be in your CC&Rs and could be removed, in my opinion, under this section. So fair housing violations and association documents, the board can remove those without a vote of the membership is just kind of the bottom line. Okay, then the next law that we're going to talk about is regarding changes to assessment collection. And this applies to planned communities and condominiums. This is the most complex law, I would say, that we're going to be talking about this morning. And probably is the thing that I've spent the most time thinking about over the past few months. And so kind of the bottom line on this law is that it's really changing the procedure that we follow for lien filings in associations. But let's start out with the easy part of the law first. Okay. First part of the law that's kind of easier is that the board needs to exercise reasonable efforts to communicate with owners and offer a reasonable payment plan to the owner before we file a foreclosure against the owner. So really the bottom line on this is that collection letters now from associations should include offers for payment plans prior to filing a foreclosure. So, management companies are if they don't already have language in their demand letters, stating that an owner can have a payment plan if they would like a reasonable payment plan, they will be doing that going forward. And of course, our firm, before we ever would file a foreclosure, we would send a demand letter to an owner. And our form letter is going to be changed to offer them a payment plan. And this is really consistent to a lot of the other procedures that different firms have filed or that different associations, have followed for many years. Okay, next part on the changes to assessment collection would be what we can lien for. So associations can now only lien for unpaid assessments, late fees authorized by the association's documents, and other collection charges. So when your management company or when our firm is recording a lien against an owner, we're only able to lien for the unpaid assessments, any late fees that are authorized or mentioned in your association's documents, or any other collection charges. And that's typically going to be defined as like maybe your management company collection charges. On the flip side, the things that we used to be able to lien for would be like attorney's fees and prejudgment interest per se, and maybe self-help charges. We can't lien for those anymore. So how do we handle those? So any attorney's fees, late fees that aren't authorized by the association's documents. So like, for example, if your documents don't mention the ability to charge a late fee. So attorney's fees, late fees not authorized by the association's declaration, prejudgment interest, and self-help charges, those can now be collected in the same manner that we have used to collect fines for many years. And so basically the procedure on that is we cannot lien for those 4 things: attorney's fees, any late fees that aren't mentioned in your association's documents, prejudgment interest and self-help charges. So we can't lien for those. But what we can do is collect them the same way that we collect fines. And that would be filing a lawsuit against the owners, obtaining a judgment against the owners, and recording that judgment with the county recorder's office. After that judgment is recorded, then the association has what we call a judgment lien, and that's effective upon the conveyance of the property, or it's paid at the time that the property sold. Alternately, we can take that judgment and we can garnish the owner's wages, rent, or any other bank accounts in the name of the owner that we have a judgment against. So really the big change here, I mean, this is going to kind of be a game changer in our industry. I wouldn't deny that. But the main thing is we have to be careful what we lien for going forward. And we have to recognize that attorney's fees and late fees that aren't authorized by the declaration, prejudgment interest and self-help charges, we can't lien for those anymore. And we just have to get a judgment against the owner to collect on those. The last part of the changes to the assessment collection law are that an association cannot sell owner's debts to a third party like a collection agency. And I really haven't seen that very often over the years, but now it's clarified that we definitely cannot do that. Okay, so let's go on to the 4th new law, restrictions on transfer fees. So a transfer fee is typically something that we see when a property is sold from owner A to owner B. Many associations have implemented transfer fees or capital contribution fees that are set up under state law in their association's documents. And what the legislature did this year is they put some restrictions on when you can and cannot charge a transfer fee. So it applies only to planned communities, and it specifically says that an association cannot charge a transfer fee or a capital contribution fee when only nominal consideration is paid, for example, $1, and it's between family members or related business entities. So, when you're doing it for estate planning purposes to transfer a property from, myself to maybe my trust that I'm setting up, or maybe I'm transferring it from one related business to another related business, or from a parent to a child, and there's nominal consideration. We can't ding them with that transfer fee because the state law now says that we can't do that. Okay, let's move on to limitations on mounted flagpole holders. So it's kind of crazy how our legislature is, borderline obsessive on, flags, flagpoles, mounted flagpole holders in a community association. It seems like every year for like the past decade, we continue to see clarifications on flag laws. So this year is no exception. This applies only to planned communities. And basically it says associations may now limit members to 2 wall-mounted flagpole holders. And so just important for you to know, if somebody wants flagpole holders that are wall-mounted, the association can limit them to only 2 on their property. Let's switch gears and talk about another important topic, which would be declarant control. And basically, just here's how this particular law works. There have been situations in the past where a declarant hangs on to the property for many, many years. And I think this bill is a result of that. In times of boom and bust in Arizona, we see different strategies by developers or declarants. Either they want to hold on to the property or for a long period of time, so they're in control of the property, typically when it's times of bust because they can't sell properties. But anyways, now there's a clarification regarding how long the developer can hold on to declarant control in their properties that they develop. So the bottom line is that the new law clarifies that the declaration must provide a date of or a method of calculating the date of termination of declarant control. So anytime there's a property, so this is probably what's going to happen in practical terms, is that developers who are now developing associations and recording CC&Rs, or possibly developers who are in control of associations right now and haven't transitioned yet, there's a specific requirement that the declaration has to provide a date of or method of calculating the date of termination of declarant control. Typically, we see this already in the documents, but maybe some documents don't have it, and now they do have the requirement that it has to be specific how to calculate or give a date for the developer to give up their property to the owner's control. The new law also clarifies a second part, and it says that the declarant control terminates not later than the date on which the second to the last lot in the planned community is conveyed to a buyer. So it gives a specific end date now. So you no longer are going to have developers in control of the property after the date on which the second to the last lot in the planned community is conveyed to the buyer. After termination of declarant control, so, after this law goes into effect, after that declarant control ends, but while the declarant still owns one or more lots in the planned community, the legislature set up some kind of things to protect the developer, I would say. And so basically the association is required to maintain the common areas and not impede the declarant's ability to develop, construct, and sell its lots. And 2, not impede the declarant's ability to develop, construct, and sell its lots, and also not impede the ability to have access to and use the common areas. So basically the bottom line on this law is it's giving further definition to declarant control. And it's putting an end to, giving an end date for declarant control, but it still gives the declarant some rights in that the new board, the homeowner control board, can't make it difficult for the developer to sell the properties that they still own, and they can't impede the declarant's ability to continue to develop and construct and sell the lots that it owns, and it can't limit them to use the common areas. Okay, let's talk about the next bill, which is just pertaining to condominiums. And this bill pertains to condominium improvements that may disturb owners and residents. Where we typically see this situation come into play is when a second floor condominium owner wants to put in wood floors, and there's a concern that there's going to be a noise issue for the owner directly underneath the second floor condominium owner. Basically, here's what the law says. If an owner wants to make an improvement or alteration that might disturb its neighbors, such as wood floors, the association cannot prohibit it as long as the owner purchases, installs, and pays for anything necessary to eliminate or minimize the disturbance. So really the bottom line on this law is that association boards should state in writing what requirements are needed to eliminate or minimize the disturbance when approving these improvements or alterations that a condominium owner may want that may disturb owners and residents. So bottom line, we need to document it in writing, what the requirements are specifically, so that the second floor owner puts in that special corking to make sure that the sound doesn't travel downstairs to the first floor owner. Okay, let's talk a little bit about 2 other laws. Casitas, ADUs, and guest houses is one of them. We saw some clarification in the statutes this year in Arizona regarding casitas and the ability to, owners to have ADUs and guest houses on their property. I just want to make it clear that associations can still enforce the restrictions in their documents regarding casitas, ADUs, guest houses, despite Arizona statutory regulations. So while those Arizona statutory regulations may give some owners the right to have these different things, such as casitas, ADUs, and guest houses, it does not take away our ability to enforce any restrictions that we may have on these different types of casitas, ADUs, or guest houses. So if it's in our documents that we prohibit them or we have specific limitations on them, we can still enforce that. Okay, the next law is regarding chicken coops. Very interesting. I hear a lot of questions about chicken coops and basically in chickens in general and roosters in associations. So let's talk a little bit about what the state law that was passed this year says. So basically what the state law says this year is that municipalities cannot have stricter prohibitions on backyard chickens than specified under Arizona law. And municipalities cannot prohibit owners of a single-family detached dwelling from maintaining up to 6 chickens. Chicken coops must be enclosed and they must meet the setback requirements. If the lot is less than 1 acre in size, the chicken enclosures cannot be higher than the fence line. Roosters are still prohibited under the new state law, and chicken enclosures must be cleaned twice a week. The bottom line here for associations is that maybe in the past we were relying on municipalities' restrictions or ordinances on chicken coops. That's really kind of changed now because there's a state law that specifically applies to chicken coops. The bottom line here is that associations, we can still enforce restrictions on chickens, chicken coops, roosters, cleaning of chicken enclosures, which might be a nuisance if it's not cleaned properly. But associations can no longer rely on city code enforcement to enforce these chicken violations. What I would suggest that associations do is that we should review your association's documents and see what sort of restrictions you have on chickens, chicken coops, et cetera, and any enforcement mechanisms that you may have to prohibit chickens. If your documents are silent on chicken coops, chickens, et cetera, then you need to fall back on what state law says, which I just went over. But many associations' documents, in my experience, do have provisions pertaining to chicken coops and chickens. Usually it's called like poultry, but many documents have that. I'd say at least 50% of the documents that we see for associations have something in there prohibiting chickens. But for those of you that don't, that you need to fall back on state law now. And it may be something that you want to implement a restriction in your CC&Rs in the future if you're having problems with this issue. Okay, let's talk about one other state law. This is a law that went into effect last year, but it's going to have implications this coming year. And so I want to talk with you about it again, just as a reminder. So I'm going to close out talking about the new legislation for 2024. All of those laws are going into effect, as I said, next Saturday, which is going to be September 14th. Now I want to talk about the 2023 Public Roadways Law. We're going to be sharing with you, if we haven't already, a blog on parking in your association. And I want you just to take a quick peek at that. And you can also look at our 2023 legislative update cheat sheet that talked about this Public Roadways Law. Okay, so the bottom line is this law doesn't apply it applies mainly to planned communities, but it's only a select group of planned communities. And the implication of this law is that if you don't take certain steps by June 30th, 2025, and we're going to talk about those specific steps here in a minute, you're going to lose your ability to regulate your public roadways within your association. And so let's just back it up a little bit. So we've received a lot of inquiries over the past, 3 months, 2 months, the past week regarding the law that was signed last year that impacts planned communities with public roadways. So basically for this law to apply to you, and the law, the number of it, if you want to look it up and read it, is Arizona Revised Statutes 33-1818. It only applies to these certain categories of planned communities. So it has to meet all the criteria here. So the planned community is no longer under declarant or developer control is number one. Number two, the CC&Rs were originally recorded before January 1st, 2015. And number three, the CC&Rs include on-street parking regulations. And then number four, the most important one, the roadways are within the community are public or dedicated to the public. So this law only applies to you if no longer under declarant control, if you're a planned community that's no longer under declarant control, if your CC&Rs were recorded before January 1st, 2015, if your CC&Rs have on-street parking regulations, such as you can't park on the street or boats can't be on the street parking or RVs can't be parking on the street. And then most importantly, that the roadways within the community are public or dedicated to the public. Okay, so what do you need to know if you fall in that category? Basically, the most important thing is if you meet all four of these requirements, in order for you to be able to enforce your on-street parking regulations for these public streets that are within the community, you have to do either of the following. So no later than June 30th, 2025. So, by June 30th, 2025. So we've got, some time to get this done, but the planned community shall call a meeting of the membership on the question of whether to continue to regulate public roadways. If a quorum of the membership is met and a majority of the owners voting at that meeting vote to continue to regulate public roadways in the planned community, the planned community is going to retain its ability to regulate those public roadways. If that happens and you get the vote at that meeting, the board of directors shall record in the office of the county recorder of the county in which the planned community is located a document confirming that the planned community continues to regulate the public roadways. If the vote fails, or if the planned community does not hold a vote by June 30th, 2025, the planned community no longer has authority to regulate the public roadways in the planned community, and any existing regulations will expire. So remember, if you're a planned community that falls into one of these categories, you really need to think about, do we want to move forward with this vote before June 30th, 2025? Now, we still have a little bit of time. Obviously, it's only the first week in September, and we're going to be continuing to talk about this law as we inch closer and closer to June 30th, 2025. But from a practical standpoint, if your association falls under this category, you really need to start taking this seriously and think about having a vote by, at the absolute latest, by like February or March 2025. And again, we'll continue to talk about this as we inch closer to the June 30th, 2025 deadline. Okay, last, like I said, this has been a heavy legislative year, right? So the law that we're going to be talking about now is the Corporate Transparency Act. This is a law that is going to require us to comply with a reporting requirement by December 31st, 2024. So bottom line is, really, the Corporate Transparency Act is a federal law that is requiring associations, planned communities, and condominiums throughout the United States to file paperwork regarding the directors and the association, by December 31st, 2024. When this law was first rolled out, January 1st, 2024, basically, we were all kind of taking a wait and see approach because this is an anti-terrorism law. And all of us were scratching our heads thinking, what the heck? How is this applying to us? There's no evidence of money laundering or terrorist activity in HOAs and planned communities and condominiums in the US. But this law has a very wide umbrella. And unfortunately, we fall under that very wide umbrella and need to comply with it. So initially, starting in January 1st of 2024, we were kind of taking a wait and see approach because there was some litigation that was pending. And one of the cases that was pending, it was ultimately determined that the National Small Business Association, filed a lawsuit. And it was determined that the Corporate Transparency Act was unconstitutional. But the way that the court read the judgment in this matter, the opinion in this matter, was that it only applied to that specific organization that filed the lawsuit. So that case is on appeal. We also have seen a discussion by the Community Associations Institute, which is a national organization, and they have talked about, they're lobbying to get this bill overturned. There is a bill that has been introduced in July of 2024, HR 9045, which would exempt community associations from the CTA requirements. However, we're not hopeful that that law is going to be signed into law by 2024. We've also heard that CAI has hired an attorney, and they are going to be filing a lawsuit to exempt, HOAs and planned communities and condominiums from this law. Well, truth be told, all that's great. We're all moving in the right direction to having associations be carved out of having to comply with this Corporate Transparency Act. However, the bottom line is right now we still have to comply with it. And the bottom line is by December 31st, 2024, we have to file paperwork so that we comply with the requirements under the federal law. The paperwork is relatively easy to fill out. Basically, we have to get information from the board members, personal information, which honestly, the government already has. So it's like your driver's license and your home address and information similar to that. The issue with this law is, though, that we have to update it every time there's a change on the board. So anytime a board member quits or resigns or moves and they no longer are on your board, or every time there's an annual meeting and we get new board members, it's a continuing update obligation. And we have to do that within 30 days. of the change. So it's kind of a hassle. It's an ongoing hassle that we have to stay on top of. Our firm is helping associations with the Corporate Transparency Act filing. So we're offering to do the filing on behalf of associations. We have a flat fee charge that we're doing for that. It's $350 for the initial filing, and then any updates that are needed through all of 2025. And so if your associations are interested in having our firm help you comply with this federal law, please reach out to me. Just to be safe, make sure that you are signing up. If you want our help to file this paperwork, make sure that you're contacting us by no later than November 1st so that we're sure to be able to meet the deadline of December 31st, 2024. Okay, we are now moving to our questions. I'm sorry that I had to spend so much time talking about the new legislation. Like I said, this year has been a very legislatively heavy year. We have 42 questions this morning for First Fridays, and I will do my best to get through them in a quick and efficient way. We'll start out right from the top. Okay, first question is from an owner. Our CC&Rs say no commonly accepted household pets shall be allowed loose or unsupervised on any part of the property. The HOA president continues to allow his cat to roam the property loose and unsupervised. The HOA president acts as if a commonly accepted household pet would only refer to dogs, and thus his cat can roam loose and unsupervised. How should owners who don't want cat poop and pee and dead birds go about getting equal enforcement of the CC&Rs? Well, that's an interesting question. So I do feel that cat would fall under the provisions that you've cited to me in this question. I would start out by sending a letter to the entire board, just stating that this violation is occurring. And hopefully the board will, talk to the president and this will be resolved. If it isn't, you could hire an attorney to send a letter. You could go to the Arizona Department of Real Estate and file a complaint against the association. And there's a charge to do that, $500, and have an administrative law judge rule on this. Another alternative would be, to file a lawsuit over this, although I kind of think this is such a small matter that I don't think I would go the lawsuit route. So hopefully that gives you some suggestions on how you can best handle this. Okay, next question from a board member. Is it expensive to change CC&Rs? I'm going to share with you a cheat sheet that we have on amending association documents and rental restrictions that I think will be helpful for you to understand the process. It really just depends on how many changes there are and how many different drafts we go back and forth on. For small changes, it's usually somewhere in the $1,500 to $2,000 range. For larger, more expansive changes, it could be anywhere from $6,000 to $7,000 to $8,000 would be kind of the average range. Okay, question 3. Our company is structured similarly to a property management agent. HOAs we manage are assessing capital improvement fee to new owners. Question, can our company, which is not an HOA, assess a capital improvement fee to new owners for the associations we manage? This is kind of a tricky question. I am familiar with the association that asked this question, and it's a unique setup. It's like a master and a sub-association, but the master association, in my understanding, is not traditionally like a normal, like an HOA that's a master association. So I'd really have to look at your documents to see if you would fall under, the requirements in order to charge a capital improvement fee. What I would recommend is that you have an attorney look at the governing documents for your organization. I don't think your governing documents I don't think you have CC&Rs. I think you just have bylaws and articles of incorporation. So I don't think, generally speaking, I have to look at everything again, but I don't think it's going to fall under one of those entities that's allowed to charge a capital improvement fee because you don't have governing documents that touch and concern land. But if you want more information about what is a transfer fee, how can we charge a capital contribution fee, what are disclosure fees, we have a great cheat sheet on this topic, and our firm's going to be sharing that with you right now. So I encourage you to take a look at that. Also know that all of our cheat sheets are on our website from Mulcahy Law Firm at mulcahylawfirm.com. Just click on the cheat sheets tab on the homepage. Okay, let's go to question number 4 from a board member. Our 55 plus community has a new owner that is not 55. Our CCNRs state each unit must have one individual that is 55 or older. One of the owners is over 55, but will never be living there. How do we go about dealing with this situation? Okay, we have a great cheat sheet on federal laws that might be helpful for you to take a look at on this particular issue. You can find that on our website at mulcahylawfirm.com. It's called Federal Laws. So it sounds to me like, let's clarify a few things. So under the Fair Housing Act, there's a specific exemption for 55 plus communities. And basically, the bottom line on a 55 plus community is you have to look at what the CCNRs state, but typically they state something along the lines of at least one resident in a unit must be age 55 or over. And so you could have an owner in a 55 plus community that is not 55, but the resident that's living in that particular unit that was just purchased by that owner has to be, at least one person has to be 55 or older. So kind of a weird situation. In your association, it sounds like one of the owners is 55, but won't be living there. And so the question is, how do we, deal with this situation? And really I guess my recommendation would be that to have your management company or your board reach out to the owner, find out who is actually living in the unit or lot, remind them of the provisions in your CCNRs. If you see a violation, you may want to turn it over to your attorney. Okay, question number 5. This is from a board candidate. Is it an abuse of power if the HOA board, after a director resigns, chooses not to appoint the next eligible candidate from the previous election and instead opens voting at the November election? This decision appears to show bias against a candidate who supports addressing common homeowner concerns that the board disagrees with. I really don't have a problem with the board handling it in this manner. I don't know what your documents state, but it's possible that it states that the board can, either appoint a director to the vacancy that was created by the resignation. Maybe that appointment is only valid until the next annual meeting. Maybe it's not. I don't know. But ultimately, the board has the discretion to make this decision. And I don't think that it is an abuse of power if they, decide that they're going to just wait and have the election in November. It's only a few months away, and I would be supportive of the board doing that. And I don't think it shows any sort of a bias. That candidate who was not elected certainly has the right to run again in November. Okay, next question, number 6, from a board member. Good people trying to make important decisions, but in so many directions, nothing important is getting accomplished. How to get a team for the betterment of the community instead of the ultimate bully behavior, power struggles, and misinterpretation from lack of experience. Okay, so it sounds to me like you've got some dysfunction going on your board and a couple things to think about. So it sounds like you have some good people who are trying to make improvements in your community, right? But you're not getting anything done. And so a couple of things that you want to think about. Number 1, we have a great cheat sheet called Using the Eisenhower Method to Accomplish Goals. So it just kind of helps you to refine all the different problems that you have in your community and then come up with what, the plan would be to work on the urgent and important things that need to get accomplished. So use that cheat sheet for that purpose. It sounds like you really are struggling with different personalities in your community, power struggles, bullying. We have a cheat sheet on how to deal with bullies. To me, everything that you're saying to me here shows me that you really need to have your board have a boot camp where like our firm comes in and has a boot camp for the entire board. And we talk about what the laws are that you need to be aware of. We talk about the problems that your association's having and how we can best solve them. We talk about personality conflicts and different types of personalities on your board and how you can all effectively work together. And I can say with 100% accuracy that anytime I've come in and given a boot camp, there has been a significant improvement in the association on accomplishing goals, working together better. The bullies learn that their behavior is, really harming the community, and either they quit or they try to work together more with the board. So I really would recommend for your association to consider having our firm come out and help you. I do the boot camps myself. We usually, it's about an hour and a half. We can do it by Zoom, and it's really a worthwhile thing to get your board moving in the right direction. Okay, question number 7. This is from an owner, and this is a condensed version because we had kind of a longer version of the question. Our board plans to increase annual assessments to hire a management company. However, they're not following the procedures outlined in our community documents. They've set a voting deadline of less than 3 weeks instead of the required 30 days notice. The vote will occur at a regular board meeting and not at a special or annual meeting as required. The board claims that they can disregard these requirements. Is this vote valid? If so, why? If not, what can members do to challenge it? So it sounds like your board is looking into, an increase in assessments so that you can hire a management company. Typically, that procedure is going to be outlined in your association's documents, your CC&Rs, how to increase your assessments. I mean, it doesn't sound to me, based upon the information that you've provided to me, that they are doing it properly. I think the best way to handle it would be to send a letter to the owner or to the board, indicating your concerns and kind of the same analysis that I gave a few minutes ago. So send a letter outlining your concerns. If that doesn't work, hire an attorney. If that doesn't work, consider going to the ADRE and filing a complaint. That doesn't work, you may have to go the litigation route. Okay, question number 8 from a board member. We've received conflicting advice about board members performing volunteer maintenance tasks, like cleaning the pool, that are typically handled by licensed and insured vendors. One management company warns this could affect our insurance, while another sees no issue. What happens if a volunteer board member gets injured while performing one of these functions? Will a waiver protect the association from a lawsuit? We have a great blog that kind of does a deep dive on this. So I'm going to provide that to you in our group chat here on Zoom and on Facebook Live. And basically, take a look at that because it gives you our deep dive on this. But bottom line is, I really think you should be using licensed and bonded contractors to handle all business tasks of your association. I mean, just even the example that you gave, cleaning the pool, that should be handled by a licensed and bonded pool company, not by a volunteer, in my opinion. That's best practices for your association. If the volunteer should get injured while performing these functions, you can bet that the association is going to get sued over this. And I've seen it happen before. Will a waiver protect the association from a lawsuit? No, likely not. The waiver is not something, you can't waive your rights on something like this. So, sometimes we use a waiver to kind of discourage people from suing the association if they would get injured. But the bottom line is it's not going to hold up in a court of law. Okay, next question from a board member. Our HOA has experienced code of conduct violations by members who disrupt contract employees through verbal attacks, excessive emails, and phone calls. These incidents have been documented but not addressed through existing processes. The affected employees often avoid reporting to avoid conflict. Is there a statute of limitations for code of conduct violations in HOAs? So we have a great cheat sheet on a board of directors code of conduct, and I would encourage you to take a look at that. It's more for board members and how they should be performing their tasks through a code of conduct. I'm not sure if this is, members in your community who are disrupting employees, or if it's board members. But regardless, there is no statute of limitations for something like this. I guess, it's a 6-year breach of contract statute of limitations. It's a 6-year 2-year negligence statute of limitations. I guess I'm not quite sure how far back you want to go. I think the key thing here is, I wouldn't wait on this type of thing. So when there's problems, I would draw a line in the sand and say, going forward, if this happens, this is what we're doing, and address it that way versus, going backwards, like something 6 years ago that happened. I wouldn't go there. That's way too long. I wouldn't even go more than 2 years, frankly. So I would say if somebody's been a problem recently, like within the past 6 months, my recommendation is send a letter and tell them to stop doing whatever they're doing. And then going forward, be very vigilant right when it happens so that the bad behavior is nipped in the bud. Okay, next question from an owner. Currently, we reside in a non-HOA neighborhood. We are curious to know more about how our neighborhood may be able to become an association of homeowners. There are several homes in our neighborhood that have become rental homes and/or group homes, seemingly because we are not an HOA. Is it possible to form a community association? I look forward to hearing from you and making the most of this opportunity to build up our community. So it is possible to form an association. You would need 100% approval of the members to form an association. But I don't think that it's going to stop group homes from coming into your association, because group homes are protected under the Fair Housing Act. So you need to be aware of that. You can take a look at our cheat sheet on federal laws, and it kind of defines what group homes are allowable, and HOAs and condominiums, can't prohibit group homes when they're allowable under the Fair Housing Act. You could limit rental homes by putting in rental restrictions in the CC&Rs or the declaration for, any association that you might form. Okay, question number 11 from a board member. A board member has been delinquent in paying her monthly assessment dues frequently over the past 2 years. Our CC&Rs clearly state that members automatically lose their right to vote as members and their right to use our amenities on site if they are delinquent. As treasurer, do I check each month? I do check this each month. I bring it to the board's attention, and they want to allow her to continue voting at our meetings. What is the correct way to handle this? Well, the board members should be held to the highest standards. They should be following the association's documents. They should be current on their assessments. So, from my perspective, this board member needs to be held to the same standard that you would hold other owners. So if your CC&Rs state that they lose their right to vote as a member and their right to use their amenities on site, then you need to take away those rights. Now, to vote as a member, there's a distinction here. This board member who's delinquent can still vote as a board member, but they can't vote as a member. So anytime there's a membership vote, this board member wouldn't be able to vote. But unfortunately, unless it says something specifically in your bylaws that the board member can't vote if they're delinquent on board matters, they still would be able to vote on board matters. But regardless, it's a very bad sign if you have a board member that's delinquent, and that needs to be rectified right away. I would recommend that the board president and the board treasurer have a discussion with this board member and find out what's going on and remind her of her fiduciary duties to the corporation. Okay, question number 12 from a board member. Our roads are private and the association takes care of the roads. They're 45 years old and need to be taken down in order to repair them, which estimates that we're getting are in the $336,000 range. It is possible that some of our members would want to pay their dues of $140 for 5 years to get enough money for the roads, or would something like that not be allowed? We're trying to think of creative ways to get our roads done. So apparently you have very old roads. You've got a very large expense to completely redo the roads. Some of the members want to do like a long range repayment plan to get enough money for the roads. I think you really need to talk with an attorney about that. It can be structured that way. I think we have to look at your documents. Like if you're going to do a special assessment, does it have to be collected each year in full, or can we do it over a multi-year special assessment? So this is something you really need to talk about with your attorney. Feel free to reach out to me if you have any questions. Okay, next question, number 13. From a board member, we have been using Vote HOA Now for many years to perform our elections with no problems. A resident is claiming that because we have not retained and produced electronic ballots for inspection, we have not complied with state law, specifically 33-1812A. We have produced all electronic records of the election results, but the resident feels the election should be invalidated. So it's my understanding that, so we look at what the statute said. It's 33-1812. It's proxies, absentee ballots definition. Okay, so under Section A7, it says that ballots, envelopes, and related materials, including sign-in sheets if used, shall be retained in electronic or paper format and made available for members' inspections for at least 1 year after completion of the election. So, if you've produced all of the electronic records of the election and any in-person voting that was done for these elections, you've complied with the statute. I wouldn't worry about it. If the owner continues to contact you on this, I would recommend that you just have the association's attorney respond to that owner. Okay, question number 14 from a board member. We have 2 gadflies. One has twice threatened to involve their attorney in a demand of the board. The second feels free to send a litany of their opinions to our association's attorney, complaining about board members and also stating they will seek the advice of their attorney. This is getting costly to other association members, as we must then inform them the HOA attorney for an opinion. May the board create a policy if in the future a resident threatens legal action after a reasonable amount of time, having not heard from their representative, allows the board to charge the homeowner for the HOA legal fees resulting from the threat, or create a new rule or a rules document which allows the board to amend or create a new rule. So I totally understand where you're going on this. It is annoying when we have gadflies who create costs in attorney's fees for an association. But these are general counsel costs, and I don't think that it is appropriate to have a policy or a rule stating that those fees get charged to the owner for them doing this. I know it's annoying, and I totally get what's happening here, and I'm sorry, I feel bad about it. But there are some costs that are general counsel costs that are honestly just a cost of doing business. And in my opinion, this is one of them. One way that you could minimize the cost on this is to not allow the owners to contact the attorney, and have the attorney just refer them back to the board. Question number 15 from a board member. After proper notice with an opportunity to be heard, when it's time for the board to vote to assess a fine, should this be done in an open session or an executive session? So it really just depends if you have a choice. Most of the time, fines are discussed in an executive session. But if the board wants to do it in an open session, the board certainly can. And that's the bottom line. Okay, next question from a board member, number 16. I am the treasurer of my association. If I want to move funds from one account to another, do I have the authority to do this? As I'm preparing to move some funds to other interest-bearing accounts, the banks are asking for a couple of directors' signatures, which I do not object to, but I don't feel like I have to justify my decisions to a property management company that suggested other banks for which interest rates are anemic. So what I would say is just be careful. If you are moving funds from one account to another, it needs to be authorized by the board. And I would not say that you have sole authority to do that. I also think that any sort of decisions that are made regarding the association's money should be discussed at a board meeting. And as a treasurer, yes, you should be guiding the discussion, but ultimately the board makes a decision. So if you are making decisions, the board should be approving it. So when you said, I don't feel like I should have to justify my decisions to a property management company, you have to justify your decisions to the board. And you give recommendations as the treasurer. The board votes on how to invest the money, where to move the money, moving the money from bank account to bank account. We have to protect the corporation to make sure that there is not any fraud or embezzlement. All of this needs to be done in an open board meeting. Next question, number 17 from an owner. I've requested financial records from my association per Arizona Revised Statute 33, 1805A. To the best of my knowledge, no evidence exists that any board since our inception in 2012 has ever discussed or voted to withhold any financial records under Arizona law. Furthermore, it is not addressed in our CC&R's bylaws, rules, or regulations, or policies. As a result, I'm asking for the salaries of each employee hired by our association within the past 12 months. Am I correct that they must comply with my records request? So basically, a couple things. Most financial records and other business records of the association are discoverable by an owner. Okay, so that generally speaking, books and records of the association, we're transparent on them, and under the law, we're required as an association to provide them to the members. However, there are certain things that are exceptions that owners are not allowed to see under the law. And one of those exceptions is how much we're paying employees in the association. So if the board doesn't want to provide you with the salaries of the employees, they do not have to. Now, that being said, there's a lot of different places that you can find the salaries, right? And so lots of times I tell boards, I think it's probably best just to be transparent and give it to people that are requesting it. But because you can find it in the budget, you can find it in the check register. But if the board does not want to provide it with you to you, they do not have to. And they can redact it from these other areas if you request records, like the bank statements to see how much Susie Q gets paid as a general manager. The board is not required to give you that information. Okay, next question. A solar energy device means a system or series of mechanisms that is designed primarily to provide heating. Given that ARS 44-1761 defines a solar energy device as including systems that are designed primarily to provide heating, could this definition extend to clotheslines since they use solar energy or sunlight to dry clothes through evaporation? Are clotheslines permitted under this interpretation of the law? So I'm kind of laughing. I mean, it's good stretch, good try. But no, I do not think it applies under the definitions for solar energy device under Arizona Revised Statutes 44-1761. Just my opinion. But if you look at subsection 8 under 44-1761, I don't think it falls under that category. Okay, question number 19 from a board member. The House Bill 2662 that becomes effective on September 14th. As the president of a planned community, may I prepare the agenda and provide said agenda to the secretary for posting? Please clarify if items on an agenda that has been posted 48 hours in advance of a meeting can be modified from the posted agenda prior to the meeting being called to order. So really good question. So yes. So typically how the agendas work is that the president and the management company create it, typically maybe with input from the board members, maybe not. Maybe it's just the management company preparing it. I mean, it really just depends. It's a case-by-case basis for each association. So just the secretary's responsibility is to, send out the agenda with the meeting notice 48 hours in advance of the meeting with this new law. So your clarification question is, who prepares it? It really just depends for each association. There's different entities that prepare it. Typically, it's the president and the management company, in my experience. Okay, and under the new law, does the secretary actually post it? Typically, no. I mean, my experience is that the management company posts it. Will be posting the agenda. But under the way the law is written, it's putting the onus on the secretary because that's one of the secretary's roles as, their official position. So the next part of the question is, if items get changed, let's say you post the agenda 48 hours in advance of the meeting and something changes, do we have to repost a new agenda? Do we have to renotice the meeting? What I would say is have enough categories on the agenda that kind of covers a lot of broad categories like new business, old business, manager's report, president's report, treasurer's report. And, you don't have to provide infinite detail. So you should be able to modify things, without having to renotice the meeting and repost the agenda. Now, that being said, if something comes up 24 hours before the meeting that you want to add, just post a new agenda and, just say there's been a minor modification to something that we're adding. If it's like a big issue type of thing, that would be what I would recommend. But I don't think you have to cancel the meeting. Just look at the issues like, okay, we're making a change to the agenda. Does it fall under one of the general categories like president's report, treasurer's report, manager's report? If so, I don't even think you need to change the agenda. But if it's something new, like amending the bylaws to reduce the number of board members from 7 to 5, then what I would recommend that you do is just post a new agenda with the additional information on it that would be new. Okay, next question, number 20. Let's see. From a board member, we have owners that would like to volunteer to be on the board next year, but the CTA requirements are giving them second thoughts to give their information to yet another database where there is no guarantee they will not be managed securely and have another national public records incident take place is their concern. What happens if we cannot form a board because of this reason? Well, here's what I would say. I think people are overthinking the CTA if they're having concerns like this. I mean, basically the information, I'm on 2 boards. I'm on my master board where I live, and then also my sub-association board. So I have to provide this in 3 different places: for my business, actually for multiple businesses that I own, for the 2 HOAs that I'm part of. And it's basically all this information is already out there. The government already has it. So I don't think that anybody should be concerned about giving their driver's license and their social security number, because these type of things it's going to be submitted on a safe website through the federal government. This is all information that the federal government already has. And I don't think that it should be an issue that, people say, I don't want to be on the board because of this. Probably what's happening is they don't want to be on the board and they're just using this as an excuse. From my perspective, if you can't find a board for any reason, whether it's this reason or you just don't have people that are interested in serving, reach out to our firm, because we have a very good letter that we send out letting people know what happens if we can't form a board. Basically, the association is going to go into a receivership, and that's very expensive for your association. So keep that in mind. If you're having a problem on this, reach out to our firm and we'll help you navigate it. Okay, question 21 from a board member. I know that the best policy is to have an agenda with all items listed, so it can be mailed or posted in advance of the board meeting. Is there any legal restriction, assuming there's nothing in the governing documents on the subject, preventing a board member from bringing up a matter that was not on the distributed agenda under the new business and having the board discuss and vote on it? So great question. I don't think that there is any sort of a restriction on this. Like, the law just says you got to give owners the agenda 48 hours in advance of the meeting. And then also when they show up at the meeting, you give them an agenda as well. That was a law that was passed several years ago. So I don't think this prohibits board members from bringing up a new topic that may be off agenda. And if you have something like new business on the agenda, that probably covers it too. But regardless, I don't think that this new law is going to allow us to not bring up something that may timely come up after the agenda is posted and we want to discuss it. Okay, next question, number 22. We are a small community, 50 units. Our HOA has spent over $7,000 on legal fees. The board will not disclose the purpose. They say there are no current lawsuits. When asked for details, they say we do not have to disclose that information to you. We did a formal request for legal bills and even suggested any homeowner information be redacted. The management company would not share the information. What rights do homeowners have to know how assessments are being spent on attorney's fees? I do think that you have a right to see the attorney's bills as long as they redact any matters that are like legal advice or anything pertaining to, pending litigation, et cetera. So I would suggest that you hire an attorney or go to the ADRE to try to get those records. Okay, next question, number 23 from a board member. A 5-member unanimous board vote is required and one board member chooses to not reply, to communicate, or participate. Can the active board members interpret this act as passive abstention, resulting in that member's vote not counting? So 4 votes becomes unanimous. This kind of talks a little bit about, something that I think is important for us to talk about. A lot of associations are using this unanimous written consent outside of meetings to get business done. And I really want to caution boards not to do that. I think that violates the open meeting law. And so if you are making decisions outside of a board meeting by unanimous written consent, which it sounds like your board is doing, you're probably violating the Arizona open meeting law. And I would encourage you not to do that. So, can the active board interpret this act as passive abstention? I guess my comment to you would be, please don't do this. So even if you're having 4 votes, this whole question is concerning. You shouldn't be doing unanimous written consent, in my opinion. You should be having board meetings, and all you need at a board meeting is a quorum. And that's how you should be deciding things. Okay, next question, number 24 from an owner. We do not have a community directory. On another street in our community, a neighbor's tree appears to be ready to fall. I knocked on the neighbor's door, but I believe they are snowbirds not living in the house. I asked our management company to notify the homeowner about the tree, since I do not know their name or phone numbers. The president of our HOA contacted me and said that the HOA is not responsible for the maintenance of private residences. What if the tree fell on someone walking by? Who would be liable? Okay, so a couple things that you could do. If you're concerned about this, you could use the Maricopa County Assessor's Office website property search function, and you'll be provided with the owner's name and mailing address. If you're concerned about this and you can't figure it out yourself, call my office. We'll help you find that person's name and address, or name and address, whether it's out of state or whatever. The assessor's office lists the owner's name, they list the property address, and then they list any other addresses where like bills are sent. So that would be, one way to handle it. You could write them a letter. Another thing you could do is contact the city or municipality that you live in and see if their code enforcement might get involved. And then number 3, I'm kind of surprised that the association is claiming that they're not responsible for the maintenance, because more likely than not, an owner can't create a nuisance and they have to maintain their property. So I think this would be a situation where the association should be getting involved. Okay, next question from the board at an association. My association is currently a developer-controlled board, but self-managed. Previous boards for my association published individual HOA policies to provide guidance on several subjects. These policies remain in force. Some are specific to the internal management processes of the HOA, while others apply to homeowners. There currently are 39 policies, and examples include policies for recreation, guest passes, etc., the dog park, employee golf benefits, etc. Okay. However, the use of a policy document as a governing document is mentioned only once in the association's rules handbook, and then only indirectly without referencing any authority granting the board for creating these policies. Is the HOA board and management team correct to use these policy documents to establish policies and procedures that do not fit within other government governing documents? And if so, must all policies be made available to homeowners? Can those apply to internal functions of the management organization be withheld for only internal use? It's kind of hard for me to comment on this because I, have to see your documents. But bottom line is that policies, it sounds kind of like rules and policies are kind of going hand in hand here. I mean, it just really depends. I'd have to see the policies to give a better analysis on this. Like internal policies that apply to like employee golf benefits, employee meal and drink policies, I wouldn't worry about those. Those seem totally fine. But the ones that are policies regarding recreation guest passes, that's probably okay too. But like estate sales and the dog park, I mean, maybe those are justifiable based upon how broad the rulemaking authority is. But this is kind of a deep dive question that's hard for me to answer on a first Friday. At first glance, I think I would suggest that your board get some advice from our firm regarding, are we overreaching on any of these things? And if we are, can we enforce them type of thing? Okay, next question, number 26 from a board member. Our CC&Rs allow our association to remedy CC&R violations. We have a homeowner who's been sent a courtesy and formal notices concerning furniture stored in an open carport for 4 months, which is a clear violation of the CC&Rs. He has racked up fines of over $2,000. The owner has promised to remove the eyesore, but nothing has been done. Do we need to give notice to the homeowner, or can we just send Got Junk to take care of the problem and then send him an invoice for the cost? Well, I'd be really careful about sending in, a junk removal company from somebody's private property and taking the property away. I would be very wary of doing something like that. I think that that's going to get you into more legal trouble, more legal entanglements than you want. I think you should turn this matter over to your attorney. I think that the attorney should escalate this. Maybe you go to the ADRE. Maybe we file a lawsuit. Maybe we send a couple letters. Maybe we pick up the phone and get this person a call and try to get them to resolve this issue would be my recommendation here. Okay, next question. From a board member, does the HOA have any right to restrict the location, size, color, and or functionality, AI enabled, of a security camera on an HOA member's property? And do the HOA members have to restrict the recordings on it should it capture the outside of a neighbor's property and or the home? So good question. If somebody's put a security camera on their property, typically in my experience, it could require a approval of the architectural committee to do that. And, the board should be telling the owner that the camera, cannot be recording other people's property. And, it shouldn't be recording. It should just be recording their property. And so the association does have some rights on this. And if it goes to the architectural approval, we would be evaluating the location, size, color, and functionality of it. Maybe not the functionality, but for sure the location, size, and the color, and the fact that it could only be directed at their property. Okay, question number 28 from a board member. Is it possible to change or add the agenda items for an open board meeting after the agenda has been printed, posted, and distributed to all the owners? And so we talked about this now I think 3 times today. So this is a good question. So yes, I think it is possible to add items to the agenda. If the agenda is very broadly worded, I think it, is easy to do. If it's something totally new and you have time, you may just want to send out, hey, here's the revised agenda. Even if it's within that 48-hour window between the time you posted it and the meeting. Okay, question number 29. We have been with our new property management company for 5 months. I keep asking for the signature card from the bank so I can sign it. I hear one excuse after the other and still no signature card. What can I do to get this done? I think, that's a long time to be with the bank to not have a new signature card. So I would go above the person that you're dealing with at that management company. And maybe you even have to go up to the president of the company and just say, hey, we need to get this rectified in the next week, or we're going to have to get our attorney involved. Okay, question number 30 from a board member. We have been charging a flat $200.50 transfer fee on all property that is sold in our community. We've been following your updates closely regarding the legislation. The information that we receive from title companies does not indicate a relationship between the buyer and the seller. Will we be able to still charge the same transfer fee, or will it be not modified to comply with the new legislation? Okay, so this is talking about the new legislation on transfer fees. And basically, it's talking about, if there's nominal consideration and there's some sort of a familial relationship, or you're doing it for estate planning purposes, transferring a property from A to B. And so I guess what I would say is typically a title company is not going to be involved when there's one of these interfamilial transfers, in my experience. So you probably aren't even going to be notified of it. But if a title company is involved and they notify you, either the seller or the buyer or whatever, or maybe even the title company, that it's one of these transfers that falls under the new legislation, then you have to look at it and determine whether or not you can charge the transfer fee or not. So, will we be able to still charge the same transfer fee? It just depends. We'll have to look at it on a case-by-case basis. What type of transfer is it? And does it fall under the new legislation? Okay, question 31. I submitted a records request 6 months ago. The records were eventually released to me were less than 5% of my requested records. What avenue can a homeowner take after several records requests that were properly submitted that go unanswered? Well, we've talked about different remedies that owners have today quite a bit. So I would document it in writing to your board, your concerns that they haven't complied with it. Number one, you certainly have a right to hire an attorney to send a letter to the board asking them to comply. You can go to the ADRE, file a complaint with them, and have a hearing with an administrative law judge. You can file a lawsuit on this. There are many different remedies that you have here. Okay, question number 32. I share my open board meeting notes with friends and neighbors that cannot attend. I offer the board an opportunity to check for accuracy, but they decline. The board has threatened me with legal action if my notes aren't accurate in their opinion. Can the board sue me for sharing my meeting notes? Now, I don't know if this person is a homeowner or on the board. A couple thoughts. If you're on the board, it's not appropriate for you to be doing this. The meeting minutes are the official record of the association's meeting. If you're a homeowner and you're maybe pumping out information on it, it's kind of unusual that you're doing this. But, you're just putting yourself at risk. So if they're not accurate, you could be sued for defamation. But if they are accurate, you should be fine. But unusual that you're doing this, I would say. Okay, question number 33. I'm just going to do a quick check to see how many total questions we have. Oh, we're getting close to the end. We have 44. Okay, so question number 33. I am a homeowner. I received a violation to remove plants and items on my front patio. There's no mention of any guidelines or criteria for front patios, which fall under private property in our CC&Rs, and items have been there for longer than 3 years, with no violation or notice about them. How can I dispute this? I also got a violation to cut my backyard shrubs below the fence line. Again, no mention in the CC&Rs, but they recently sent a newsletter saying shrubs need to be 6 feet. Do CC&Rs override any notice? Rules and regulations, bylaws, even if not mentioned in the CC&Rs. Also, other people have items, so it becomes subjective. How do I dispute this? Okay, it looks like we've got several issues here. You're an owner. Apparently you have some plant and items on your front patio. I haven't seen a picture, so I don't know, what this looks like. If I were looking at this particular issue, I would look at the CC&Rs. Like, does it say anything about nuisance or that people have to maintain their properties? What does it look like? I don't know if they have been there for longer than 3 years. You may have an argument that, hey, this has been here like this and you haven't done anything on it. Therefore, you've waived your right. The backyard shrubs being above the fence line, I think that's a maintenance issue. And I think the association can definitely enforce that violation. So I guess the question is, how do I dispute this? If I were you, I would open the lines of communication with the board. I would talk to them about it and say, hey, I received this violation letter. Can we talk about it? You may want to mention that they've been there for more than 3 years, find out what their concerns are on the front patio issues. Maybe you can just clean things up a little bit. Everybody will walk away happy. On the, bushes being trimmed, I think that's a very reasonable request, and I think you should just do it. Okay, question 34 from an owner. According to the Arizona state statutes, what can or cannot a personal representative for an owner do? Can they participate in monthly meetings? So short answer would be yes. As long as the owner puts it in writing that the designated representative has, the authority to act on their behalf, they can attend monthly board meetings. Yes, they can speak on behalf of the owner. Can they discuss HOA rules and regs with the board? Yes. Can they serve on committees? Only if the board lets them. It would be unusual, for a board member to appoint a non-owner to a committee, or a board to appoint a non-member to a committee. But I suppose if the board's okay with it, they could do that, but very unusual to do that. Okay, question number 35. How long do board members have to respond to emails? Good question. There is no set law on this. I would just say customary business practices would be, within a couple of days. Just try to have good communication if you're a board member. If something comes in and you're really busy at work or something else is going on in your life, say, hey, I received your message, but I won't be able to respond until the weekend or whatever. Just have good communication back. Question 36. The chicken situation doesn't apply to HOAs in towns. Is that correct? Well, no, that's not correct. So the new legislation is state legislation pertaining to chicken coops and chickens, and it overrides any sort of city ordinances or county ordinances that may have existed before. And associations, CC&Rs, can still be enforced against any of these owners who may, have chickens, and the association CC&Rs cover provisions in the documents that may allow or not allow chickens and things associated with chickens. We can still enforce those. But the bottom line on the chicken law is that it's a state law now. And so we need to look to the state law. We don't go by each municipality or each city's laws. It's now a state law. Question 37. How far back can you go? 6 years. I tried to get HOA misuse funds back, misused by one board member. And so basically, it sounds like you have some sort of a situation where a board member may have misappropriated funds. Like, how far back can you go? Typically, that's going to be like a breach of fiduciary duty issue. So probably 2 years. You might be able to argue breach of contract 6 years from the date that if there were any sort of contractual breaches in the documents for the association. But the bottom line would be, if you're pursuing a former board member or a current board member for misappropriation of funds or something like that, you need to act promptly. Okay, next question, 38 from a board member. In regard to the Corporate Transparency Act, what protections do board members have if so many details and photos of our ID are submitted? No one will ever want to serve if frightened away. Well, I think I kind of covered this a little bit earlier, but under the Corporate Transparency Act, all of that paperwork is being submitted to the federal government by a secure website. So I don't really think there should be any concerns regarding, this, in my opinion. So I would suggest that what I would recommend is that you just take a look at the website on this. You can Google Corporate Transparency Act and you can see that everything's on a secure website. I don't think that is something that people should be overly concerned about. With regard to, if you're hiring our firm to submit the paperwork on behalf of the individual board members, we have a secure website and we have strategies in place to make sure that none of this information would be, it's all password protected. There are only 2 people in our office who would have access to it, myself being one and another attorney in our firm. And so I wouldn't have any concerns about that, so I think it's a good question to ask, but it's not something that is an reaching concern, in my opinion. I don't think that people should be worried that this is going to get on the dark internet or something like that. That's not something that we ever would foresee happening. Okay, question number 39. From a board member regarding the Corporate Transparency Act, management companies are providing incomplete and inaccurate information. Can an individual board member submit his or her BOI, beneficial ownership information, to FinCEN directly, or does the HOA have to file the report collectively with board of directors' personal information source document as an association? Also, it appears the BOI report would need to be updated each time the board of directors is changed during the year. So that's correct. That statement is correct. It's our opinion that all information should be submitted at once. And so what I would, suggest would be that the FinCEN reporting form is structured for entities to file their reporting information collectively, including both the entity information and all required BOI for each beneficial owner at the time of the initial filing. However, an individual beneficial owner may submit their BOI directly to FinCEN and request to be issued a unique FinCEN identifier number that the entity can then submit in its initial filing as the BOI for the beneficial owner. We're not recommending that you do that because we think it's unnecessary, frankly, and it's an additional step, but the right's there and you certainly have the right to do that. Again, remember that the report that we submit under the Corporate Transparency Act will need to be updated each time any change occurs to the reported information. So anytime there's a change in directors, a change in a management company, or even a change of address for a beneficial owner. Okay, last but not least, we're getting down to the end. It's question number 40, and it looks like we have a total of 44 questions. So getting close to the end. Can you clarify whether the CTA is an annual filing or only required to file when there are changes? So we have to file the initial filing by December 31st, 2024. And then any updates, like we just discussed, would have to be filed within a timely manner of 30 days between the time that the change occurs. Question number 41. The CTA reporting due by 12/31/2024. If our HOA has not filed to date, despite new board members in February 2024 and an additional change in August of 2024, what's the best approach for filing in 2024 to, what's the best approach in 2024 to handle this, to avoid penalties? Well, remember, it's not even due until December 31st. So from our perspective, I would just file it right before December 31st. And I would, although there have been changes throughout the year, we should just file as of whatever date we file. That would be my recommendation. Next question would be number 42. Our board has experienced 50% year-to-date turnover in directors during 2024. And former directors announced that they will not comply with the CTA, apparently. If the board requests for CTA regarding identifying information, are former board members required to be included on CTA reports for 2024? And if so, how can they be compelled to cooperate? Okay, so when we file this before December 31st, 2024, we are only filing it for the directors that are the existing directors at that time. So if directors don't comply, we need to comply with this law. So apparently it looks like they're going to resign from the board. I don't know. Or maybe some directors are saying, hey, we're not going to comply on this at all. So then I have to take it as we go. This is a new law. I probably would just put their name down there, and then just maybe if there's an ability for us to say that they're refusing to comply, we could do it that way. Question number 44. Our HOA has a property management company, but we would like to do the CTA filing ourselves without them charging us. Each board member has already submitted our personal info and created our own FinCEN ID. Can we compel the officer of the property management company to give us his or her FinCEN ID so that we can be our own reporting company for the CTA form? So yes, I think that's a reasonable request and your management company should comply with it. But please, please, please be careful. You have to remember boards change and you want to make sure that this is complied with, even if the board changes. So you may really want to have a third party helping you with this so that, if somebody who's handling it right now gets off the board and then you're not complying with it in the future, it could be problematic. So I kind of do like having a third party like your management company or your attorney handling this for you. Okay, last question for this morning. It's tough to find owners to serve on the board. One of our current directors has threatened to resign if forced to comply with the nonsensical CTA. What's the likelihood of our being penalized if we do not comply? Okay, so great question. From my perspective is my recommendation would be, okay, if our current director has threatened to resign, then, I think we have to maybe get me involved as the association's attorney and tell them that basically this is a requirement under federal law that we have to comply with. If you don't comply with it, we're violating federal law. We have to disclose your name. We're going to notify the government that, you're refusing to comply with this. And, we feel it's a breach of your fiduciary duties to the corporation. Will we be penalized if we do not comply? We're just going to have to take it on a case-by-case basis and see what happens. It's possible that there could be penalties, although I'm doubtful. I think what will happen is we'll get like a warning or a couple warnings before they will comply, before they will start penalizing us, but we'll just have to take a wait and see approach. Just some closing thoughts on the Corporate Transparency Act. I can sense that there is a level of anxiety in our industry about this new law. And I understand where you're coming from, but I have been doing this for over a quarter of a century, working with associations. I've seen new laws come and go since 1995. I've been monitoring legislation, helping associations interpret legislation. And I would like to give, just my personal thoughts on this. Okay, I think it's a box checker. Corporate Transparency Act is a box checker. Yes, it's intrusive, asking for all this information, but it's something we have to comply with. And I don't think that board members should be freaking out about this the way that they are. I think that we have to recognize that we give similar information to the Corporation Commission. We give them our board members' names and their property addresses already in Arizona. If we have a driver's license, we are registered with the Department of Motor Vehicles, right? And so the government already has that information. And the government has our social security number. And a lot of this information they already have. So this shouldn't be like some sort of a freak out. It's not like how much personal money do you have in your bank account as a board member? No, they're not asking for stuff like that. So I think what we need to recognize is it's a box checker. Don't freak out about it, okay? We have to comply with it by December 31st, 2024. Looking forward to 2025, I think something's going to happen, whether there's going to be new legislation on the federal government side that carves out associations and planned communities and condominiums, or there's going to be a case that's decided that carves us out. So I don't think this is a forever thing. I think this is a box checker for December 31st, 2024, and then a wait and see thing in 2025. So I encourage everybody to have a healthy attitude about this and to, if you're having trouble as a board with board members that are refusing to comply with it, maybe we all hop on a phone call and we talk about it and get a higher level of comfort for everybody. Okay, that's it for today. I cannot believe it. We made it through the seminar in an hour and 41 minutes. We covered a lot of territory today. We talked about the new legislation in Arizona that's going to be going into effect a week from Saturday. We gave you a really great cheat sheet that's going to give you just kind of a quick summary of the laws. We talked about the Corporate Transparency Act, right? and what we're going to be doing to comply with that. We talked about the public roadways law that applies to planned communities that we all need to comply with if we want to keep maintaining, and enforcing restrictions on our roads effective June 30th of 2025. We covered a lot of ground there. Then we covered 45 questions from all of you as part of our first Friday here today. So great session today. Thank you so much for being here with us. At one point, we had over 100 people on the call, so that's awesome. Just some concluding remarks. Don't forget that our next virtual HOA Condo Academy with the neighborhood services departments from around the Valley is going to be on September 17th, Tuesday, September 17th at 11 a.m. We always have those neighborhood services virtual HOA academies the third Tuesday of every month at 11 a.m. The next class is going to be on the ABCs of enforcement for HOAs and condos. We had a lot of enforcement questions today, so I hope you tune in and we can do more of a deep dive on how to handle owners that are not complying with your documents, or maybe you're an owner and the board's not doing what they're supposed to be doing. We're going to cover both angles on that. Also, I want you to know that I'm going to be teaching 2 classes in the city of Scottsdale live in September and October. So I wanted to make you aware of them. On Monday, September 16th, from 1 to 3 p.m., I'm going to be teaching a class with the Scottsdale Neighborhood College on Community Association Finances 101 and how to prevent fraud and embezzlement. And we're also going to be doing a quick legislative update in person at that class. Also, we'll be teaching a second class in person for the Scottsdale Neighborhood College on Monday, October 7th from 1 to 3 p.m. on how to effectively work with management companies. You can find out more information on our next virtual HOA Academy, which is September 17th, or the 2 Scottsdale classes, September 16th and October 7th, on our website at mulcahylawfirm.com. Don't forget that our next live virtual First Friday event is going to be on Friday, October 4th at 9 o'clock a.m. So make sure you bring your questions for us for our next First Friday event. Lastly, we would genuinely appreciate it if you would consider leaving our firm a review on Google and or on Yelp. We're going to be sharing a link in the chat on how to leave a review. We are always happy to get feedback from all of you about how we can improve these classes or how you feel about these classes. If you'd like us having the free First Friday call-in, any suggestions that you have or any positive comments that you have are very much appreciated on Google and or Yelp reviews. So everybody take care. Hope you have a great upcoming weekend and look forward to seeing you at one of our future events. Take care, everybody. Bye.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review.